Good evening, everybody. Thank you so much for logging in on time and welcome back after the break that we took. With the indulgence of the presiding judge and the honorable bench, before we proceed, allow me to relay three special greetings. The first greeting is from President Emeritus of the International Court of Justice, Abdul Faki Yusuf, who was an ICJ judge who took part. Antoinette, maybe you could mute. Who took part in the real ICJ advisory opinion that we are discussing today. We were with him at the African States Sensitization Conference together with Justice Emukule on Wednesday this week. And a few hours ago, I was with him also at Kabarak University, where he delivered the keynote lecture on the inaugural Bonaya Godana lecture. So we spoke to him about this Green Law Global Initiative ongoing moot court, and you could see how disturbed he was that he didn't know earlier, and he insisted that we invite him for a session or two, that he will be part of the bench in the 2027 edition. That is President Abdul Faki Kawi. Also received greetings from his replacement. So he retired from the International Court of Justice shortly after that advisory opinion. He retired, and his replacement is a Kenyan, Professor Judge Phoebe Okoa. We were also with her at the conference, and also a few hours ago we were with her at Kabarak University, and she also relayed her greetings. She, however, cannot be part of the moot, not until maybe she retires or something, but she relayed her greetings, and she's always there for knowledge support. And then lastly, received greetings from former Chief Justice of Kenya, Dr. Willy Mutunga, who also attended the inaugural Bonaya Godana lecture, and he also passed his greetings and requested to be part of the moot in 2027. All right, so as we proceed, welcome to the quarterfinals, quarterfinal 1 of the Green Law Global Initiative 2026 International Moot Court Competition on Climate Justice and Environmental Governance between GLGI, the highest ranking institution in the preliminaries was JKUAT. So JKUAT will take on UMMA University. JKUAT will represent Azania, and UMMA University will represent SECA. This court is now in session. Presiding judge is Justice Helen Omondi, assisted by Justice Matthew Emukule, together with Justice Antoinette Ogange. Participants, other counsels, you have 30 minutes, and then 10 minutes each for rebuttals. All I can say is this preliminary round will take a different session as the presiding judge will guide. The court is now in session. I hand over the proceedings to the presiding judge. Welcome, presiding judge.
Thank you very much, Counsel, and a very good evening to all of you. Warm greetings and congratulations for those that are making it to the... Can you hear me? I hope you can hear me.
Perfectly well.
Making it to this quarterfinal. We have your submissions on the matter, and this now being a different stage, we will adopt a different approach where the court will interrogate counsel on a few issues of law, issues of concern that you'd be able to respond to. And so we will start with the counsel that are representing Azania in the matter, and I will invite my colleagues, my sister, Judge Ogange, and my brother, Judge Emukule, onto the panel. I will first ask my sister, Judge Ogange, you have issues that you'd want Counsel for Azania to respond to?
With due respect, presiding judge, before Judge Ogange comes in, kindly participants switch on your videos. Those are the rules for the virtual court. Levis, Castro, Nahum, Fozia, your videos should be on at all times, as well as the judges as far as possible. Where you can switch on your camera, please do so. Thank you so much. Back to you, presiding judge.
Thank you very much. And perhaps before Judge Ogange raises the questions, perhaps the team that is representing Azania would want to introduce themselves so that the judge would be able to indicate who she's directing the question at, or if it is a general one. Thank you.
Thank you so much, Your Excellency. My name is Kamara Castro Ouma, appearing with my co-counsel, Levis Carrera Ndegwa. To be specific, I will be addressing issues 1, 2, and 3, whereas my co-counsel will address issues 4, 5, and 6. Thank you.
Judge Ogange, any particular issue that you'd want Counsel to respond to?
Okay, thank you, presiding judge. Mine is just a general question to either counsel. The state of Azania has submitted that TWCCEA is necessary to meet Azania's international obligation. Can you now demonstrate that less restrictive alternatives, for example, improved waste management systems, would have been insufficient? Yes, Counsel?
Good afternoon, Your Excellencies. I'd like to first of all to confirm whether I'm audible and whether I'm visible as well.
Yes, you are. For both.
Much obliged. My name is Karera Levis Ndegwa, Counsel representing Azania. I will be handling issue number 4, 5, and 6 in regards to the question that has been fronted to us, which is whether we contend and whether we do affirm that less restrictive measures rather than the ones that we impose, the EPR regulations and the digital traceability, whether they will have been sufficient or insufficient to tackling this issue of apparel-related pollution. We do submit that less restrictive measures or alternative measures would have in fact not have been sufficient to address this particular issue, because it is an issue that we're trying to curb directly from the source. We rely strictly on the polluter pays principle. It is the members of this particular sector who are responsible for the pollution that is affecting the coastal communities and the children in this particular area. As such, it is their responsibility, as mandated by the polluter pays principle, to in fact ensure that the cost of mitigating and the cost of reducing this effect is in fact falls squarely upon them. That is number one. In regards to number 2, the EPR and the digital traceability as well ensure that the apparels can be coordinated and that they can be monitored all the way from the point of entry into the country, all the way to the point of disposal. So this has created a chain reaction from the first moment that these products come into the country until the end of their life cycle. So it is their responsibility. We have placed this responsibility upon them by extended producer responsibility to ensure that, for one, through the grading requirements, the apparels that are coming into the country are in fact sellable and that they are in fact marketable and they won't end up causing more harm to the environment. If this is sufficient, I don't know whether that is sufficient, Madam President.
Judge.
Okay, thank you for your response. Thank you, presiding judge.
Judge Emukule, are you there? I suspect maybe your mic is not on, Judge.
Mute?
Yes, we can hear you now.
You can hear me now. Thank you. Counsel Kamara.
Yes,
On the
sir.
issue of traceability, let's follow that. What would you say to the question, at what stage should an importer of second-hand clothes be required to ensure or to comply with the requirement that the origin of the clothing is actually traceable? At what stage? At the point of importation or at the point of acquisition? Do you understand the question?
Yes,
Kamara?
Yes, I've understood your question.
Thank you.
Thank you for that question, Honorable Judge. To respond to your question, it connotes with the common but differentiated responsibility upon state. And the question clearly seeks an intervention. At what point should state intervene when it comes to second apparel? One, is it either at the point of importation or is it at the point of acquisition? Your Lordship, it has to be appreciated the fact that the states have to act within their sovereignty and within their jurisdiction. When it comes to matters climate change mitigation, to this extent, then it implies that at the point of entry into a state, then state is supposed to impose specific regulations that are supposed to regulate the second-hand apparels. Your Excellencies, the common but differentiated responsibility requires state to collaborate and also consider the fact that states have different capabilities when it comes to climate change interventions. But also, it is also important to connote that the advisory opinion that was rendered in 2025 specifically gave obligation to state to come up with measures that can regulate both public and private sector within states. And this justified the fact that the state of Azania came up with measures that at the point of entry of second-hand apparels, there is an intervention through regulation as well as compliance to specific regulatory frameworks provided by the state. To support my argument, under paragraph 282 of the ICJ advisory opinion, specifically it was stated that states have a mandate to regulate both sectors, and that connotes both public and private sector. To also reinforce my argument, which is on the case of Uganda Foundation v. Netherlands, the Dutch Supreme Court specifically stated that the state of Netherlands could not cite that other states also have responsibility when it comes to second-hand apparels. However, it also has its own responsibility to come up with the laws within its state to ensure there is regulation and it meets its obligation on climate change matters. If that's sufficient, yeah, thank you.
Thank you. Thank you, President Judge.
Very much. And for me, Counsel, I would want either one of you to respond to this, just so that I get a sense of your familiarity with the international instruments and principles that govern what we are looking at. And in this regard, where would you place public participation before legislation? And is there any particular principle within the international realm that would maybe speak to this? Maybe I could expound so that it is much more clearer. There is the complaint by SECA, the business community, the small scale traders, regarding the legislation. The question is, would it have been different if there was public participation? And if so, where would this fit in within the international instruments?
Thank you, Your Lordship, for that question. I will take the question. Your Lordship, the International Covenant on Civil and Political Rights indeed guarantee public participation in legislative matters. It gives the people the opportunity to participate in the legislative processes and also present their views in matters that concern them. Your Excellency, it is important to note that during the enactment of the Impact Act, all the processes were followed by the Republic of Azania. And to this extent, this SECA, which is in contention with the enactment of that act, specifically proceeded to the Supreme Court of Azania, and the Supreme Court of Azania specifically referred the matter to the regional court. The regional court indeed found that the specific enactment was as per the human rights obligations. Your Excellency, to this extent, we submit that indeed public participation was done, and the state of Azania met its obligation on matters public participation. It is important to mention that under Article 25 of the International Covenant on Civil and Political Rights, public participation is provided and it gives the people the opportunity to participate in legislative matters. The same is also provided under the Universal Declaration of Human Rights, as well as the African Charter on Human and People's Rights. Your Excellency, to this extent, we submit that indeed the due process was followed in public participation, and to this extent, there was a contention that was raised at the Supreme Court of Azania, and the same was again affirmed by the regional court. Hence, it means this was justified and this test was met. Thank you.
Are you familiar with the Rio Declaration, perhaps? Principle number 10? You interacted with that?
Yes, I am familiar with that.
That would perhaps also apply in terms of inclusive environmental inclusivity of the population in environmental governance.
Yes, it brings the inclusivity of the population in environmental governance. That is Principle 10 of the Rio Declaration.
Thank you, Counsel. Okay, we will move on to another set of issues that we would want to be addressed. And I will then invite my sister, Judge Ogang, to now frame your questions to Counsel for SECA.
Thank you, Presiding Judge. To the Counsel representing SECA, the question can be taken by either Counsel. The submissions by SECA have largely been pegged on the fact that Azania has violated international obligations. So are you aware which specific binding rule has been breached, given that environmental law is generally within state sovereignty? Basically, the court is asking you to support your submissions on what Azania has done to violate international obligations.
I'll take the question, Your Excellency. May it please this court, and with respect, the premise of the question requires a clarification from the perspective of the applicant seeker. Our submissions are not that the Republic of Azania violated international law by regulating. On the contrary, seeker fully accepts that environmental regulation falls within state sovereignty, which is that our submission is narrow and legally precise, which states that Azania breached binding international obligations in the manner in which it exercised that regulatory power, which is the binding rules engaged are not the binding rules engaged are not discretionary policy norms. And also it breached the GATT 1994 obligations, which was also the binding treaty law, as Azania is bound by the WTO agreements, including the GATT of 1994, which impose hard legal obligations and not soft guidance, states that there is the violation of the GATT, Article XI, which talks about the quantitative restrictions. As the treaty imports prohibitions and licensing barriers operate as de facto as quantitative restrictions on second-hand apparel imports, contrary to Article X1, unless justified under Article 20 of the GATT. And also, the failure to satisfy the GATT Article 20B and G, respectively. Even assuming provisional justifications under environmental exceptions, Azania breaches the chapeau of Article 20, a binding obligation, as authoritatively interpreted in the WTO appellate body jurisprudence. In the US shrimp, the appellate body held that environmental measures must not be applied in a rigid and unbending manner without regard to the differing conditions. We could also say that, Your Excellency, Azania's uniform digital traceability and EPR requirements imposed on multinational importers and informal traders alike replicate precisely the conduct condemned in that case. Similarly, under the Korea beef, a measure is not necessary where reasonably available and less restrictive alternatives exist. To answer your question, my last point will be there was the breach of binding African human rights obligations. As we submit that Azania is bound by the African Union human rights system, including the African Charter on Human and People's Rights, which imposes immediate obligations, under Article 15, which provides for the right to work, Article 22, which provides for the right to development, and also Article 24, which advocates for the right to a satisfactory environment. In a relevant case law of Serak versus Nigeria, the African Commission made clear that environmental protection must be pursued in a manner consistent with economic and social rights, as states may not protect the environment by destroying the economic foundations of the affected communities. If I've answered your question, Your Excellency, let me finish by introducing myself. I am Juma Nahum, appearing before you from UMMA University. May it please this court.
Thank you, Counsel. I realized we were not communicating. I don't know whether you can hear me. And let ask you to
I can hear you, Madam. Your Excellency, presiding.
This is why I posted it on the chat, but thank you, Ms. Juma, for that.
Much obliged.
Thank you. Judge Emukule for Seka. Counsel for Seka. It's a different counsel introducing them, addressing the court. Please introduce yourself first. Thank you.
Fauzia Hassan.
Yes.
Are you there? This question is to you. This question is to you, Counsel.
Okay.
we go back to the basics. What, in your view, was the basic tenet of the ICJ opinion to the United Nations General Assembly, advisory opinion? What was the basic tenet or holding?
Thank you, Your Excellency. Much obliged. The central tenet of the ICJ advisory opinion to the United Nations General Assembly is that states have a positive obligation under international law to prevent environmental harm within their jurisdiction where there exists foreseeable risk of environmental harm. At the same time, the court emphasized that such obligations, yes?
Go on.
Thank you. At the same time, the court emphasized that such obligation must be implemented in accordance with existing international legal frameworks. Similarly, international law does not operate retrospectively. This was confirmed in Bosnia versus Serbia, whereby the court held that international obligations must be assessed based on the responsibility of the states at the time of the alleged conduct. I hope that is sufficient, Your Excellency. The basic tenet is that the ICJ affirms a positive obligation. Thank you.
And follow up that question. What are the consequences of a state's failure or default in taking action to adopt and mitigate the effects of climate change? And who is responsible?
Sorry, Your Excellency, can you kindly pardon the question? Sorry.
The question is, what are the consequences of failure or default in adopting measures to mitigate the effects of climate change? And who is responsible, who liable? Did you get my question?
I did processing, Your Excellency. Okay. Who is the consequences of failure to this positive obligation? It incurs a state responsibility, international state responsibility, and to answer the question on who is responsible, according to the polluter pays principle, those who produce the harms are the ones who are responsible. But in connection to our present case, the second-hand apparel trade, textile waste, those who are responsible for this textile waste are not just the people of Azania, the citizens of Azania, because the waste originates also from global north. So in terms of international legal responsibility, states' responsibilities are engaged in accordance to the state. Sorry, Your Excellencies, I stand guided by this honorable court.
Thank you, Counsel. Presiding Judge, that's the end of my question.
Thank you. Thank you. And for me, Ms. Juma or Ms. Fauzia, either of you can answer this. Part of Azania's argument is that they have signed certain international instruments and are therefore obligated to put in place measures that would ensure implementation of protection of the environment. Are you familiar with the principle of no harm rule?
Yes, presiding judge.
That will inform my next question. So if you are familiar with that principle as a customary international law, would you be able to identify perhaps any legal instrument that addresses this? Perhaps some declaration?
To answer your question, Judge Helen, the trail smelter arbitration was the first instrument to establish the no harm rule, and similarly, Principle 21 of the Stockholm Declaration and Principle 21 of the Stockholm Declaration.
So familiar with the Rio Declaration?
Yes, the Rio Declaration also affirms this principle.
Specific on which principle number?
Principle 2, Your Excellency.
Right. So we go to the next round of questions, and this will it's simply interrogating again a few issues. And I'll start with Azania, Judge Ogange.
Thank you, presiding judge. Again, to either counsel. So how does the state of Azania reconcile the strict regulatory compliance with the fact that 2.5 million livelihoods are affected and are dependent on this sector?
Much obliged, UX. So sorry about that. Much obliged, Your Excellency. I'd like to get confirmation once again whether I am audible and whether I'm still visible. Kindly.
Yes, you are audible and also visible.
Much obliged. As the state of Azania, we do acknowledge that there are 2.5 million people who are actually employed by this sector. And it is this very recognition that prompted us not to ban the trade entirely, but rather to impose regulations upon it. The reason why we've imposed these regulations is because despite the 2 million people in the country who are employed by the trade, there are also 38 million people as well in the country who are not employed by the trade. These are also people who do need the state's protection, as it was imposed by this honorable court's ICJ advisory opinion last year, that we do in fact have an obligation and a duty to protect the environment. In conclusion, we could have come to this before this honorable court and decided to cite the WTO European Community's asbestos case, whereby France's ban on asbestos was justified under WTO rules for purposes of protecting human health because it fell squarely upon the exceptions that have been provided for by GATT, specifically under Article 20. I hope that is sufficient to bring us back. We do acknowledge the 2 million people who are employed by the sector. However, we also take into account 38 million people who are not employed by this sector. We have not done away with the trade. However, we have only made it more focused in such a way that it benefits the 2.5 million people and 38 million people as well. I hope that is sufficient, Your Excellency.
Okay, thank you for your response. Thank you, Presiding Judge.
Much obliged.
Thank you very much. Judge Emukule, again for Azania.
I have no particular question to Azania at this point. Thank you, Presiding Judge.
Maybe I'll just follow up from where Judge Nangi has left off with regard to Azania. What would you say about the measures adopted pursuant to the ICJ advisory opinion? Would you say that it justifies the limitations on international trade under environmental and human rights exceptions, bearing in mind what ICCPR and ICSCR say? The two covenants on socio-economic rights.
Thank you, Your Excellency. I will take that question. Your Excellency, it is important to note that the ICJ advisory opinion rendered in 2025 specifically addressed the question on lex specialis. Your Excellency, the ICJ advisory opinion addressed itself that climate change law does not exclude other rules. To be specific, under paragraph 169 of the ICJ advisory opinion, it specifically stated that climate change treaties are the principal instruments addressing climate change. However, it does not follow that they replace other rules and other principles of international law. To also add, under paragraph 165 of the specific advisory opinion mentioned, the court specifically stated that when several rules bear a single issue, then they should be interpreted to the extent possible so as to give rise to a single set of compatibility. Your Excellency, we clearly mentioned that inasmuch as the ICJ advisory opinion addressed itself on lex specialis, it is important to state that there is also under paragraph 283 of the specific decision that there are specific international common goods, and climate is considered as one of the international common goods. To that extent, it puts the agra omnes obligation upon states, whereby all states remain concerned on matters of climate. To this extent now, Your Excellency, there is also a legal framework that is already provided under GATT that allows limitation to trade when there is environmental violation. For instance, if country is preserving public health, preserving animal and plant health. Pursuant to Article 20 of the GATT. Your Excellency, it is important to note that these both agreements have to be interpreted compatibility as already decided previously by the advisory opinion. To this extent, we submit that this limitation indeed just in the ICJ advisory opinion indeed justify the limitation on trade based on the specific compatibility and interpretation of the specific laws. Your Excellency, the state of Azania in coming up with the act did not impose an arbitrary or discriminatory law that to this extent excluded the second-hand apparels. However, it basically acted within its obligation with consideration of lex specialis principle. It did not get rid of international trade law. However, it basically complemented it and acted within Article 20 of GATT, but also within Principle 12 of the Rio Declaration. Excellency, I hope that answers your question.
Thank you very much, Counsel. We will then now also turn to SECA, and I will invite my sister, Judge Ogange.
Thank you, Presiding Judge. I have no further questions for SECA.
Mupule?
One question for SECA, and it's a general question. Under the secular regulations for regulating importation of second-hand clothing, besides the obligation of the state, this question goes to SECA Counsel Jomo. Should there be a fund, and who would contribute that fund? The Global North, which is responsible for 96.4% of global warming, or the South, which is responsible for 4.6% of global warming? I invite you to look at the ICJ opinion, because it left that question completely open. And as future policymakers and scholars, what would you say to that omission of provision for the funding of green energy, essentially? Aum.
Present and much obliged. Kindly, I'd like, at the first part of the question, there is a part I've missed out. If you could kindly repeat, consider pardoning.
Basically one question.
Okay.
The ICJ advisory opinion deliberately, in my view,
Okay.
omitted mention as to the state responsibility global responsibility for mitigating the effects of global warming of greenhouse gases. Who do you think should contribute to, or should there be a fund to mitigate greenhouse gas effects on the global south?
Thank you for that question, Your Excellency. I'd first like to start to state what the ICJ deliberately did not decide and why. Honorable members of the court, the ICJ advisory opinion did not allocate financial responsibility numerically between the global north and the global south. The court refrained from doing so, and this was because the allocation of finance involves political, economic, and distributive choices. Also, the same advisory opinion has the advisory jurisdiction, which is limited to the legal interpretation and not fiscal design. And also, climate harm stands to be collective, cumulative, and also historically differentiated. However, leaving the question open does not mean the court left a legal vacuum. The legal framework the ICJ did affirm was that the court anchored climate finance within existing binding principles, particularly the common but differentiated responsibilities and the respective capabilities. And this, as reflected in the United Nations Framework Convention on Climate Change reaffirmed by the court, establishes two legal realities. One, that all states have obligations to act on climate change, and also that not all states bear the same burden in light of the historical emissions, the economic capacity, and also in terms of technological advantage. And this principle directly answered who should fund green energy. Honorable members of the court, I'd also like to answer the question by pointing out the obligation of conduct and not result. The ICJ made clear that climate obligations, including finance, are obligations of conduct to assist, to cooperate, and also to act in good faith towards collective solutions. We submit that Seeker's answer to the court's question, Honorable Judge, that in Seeker's respectful view, that green energy financing must primarily be borne by those states with the greatest historical responsibility and the greatest capacity, namely the global north, and while the global south must be enabled, not burdened in its transitions. And this follows directly from law and not ideology. As this global north, as this global north, it contributes to the overwhelming share of historical emissions, and also it possesses the financial and technological capacity. But as well, the global south contributed minimally to the global warming, and also it faces the harshest climate impacts. And I'd also like to point out before this honorable court that while funding is essential and not optional in this case, honorable members of the court, the ICJ recognized that climate obligations without means of implementation stand to be illusory. As without predictable and adequate green financing, mitigation in developing states become impossible, and also adaptation gaps widen. And we could also say that the climate regulation risks become punitive rather than being transformative. And this is precisely why the Paris Agreement embeds finance, technology transfer, and also capacity building, which stands as core pillar of climate action. If I've answered your question, Honorable Judge.
Thank you very much for your answer.
Much
Presiding
obliged,
Judge?
Your Excellency.
Thank you. Thank you, Counsel. Team representing SECA, the lived reality, and I think this is the difficulty in this particular matter, is on one hand, there's the restriction of market access and disrupted livelihoods that you lament about. And then on the other hand, are the continued exposure of children and the coastal communities to apparel-related pollution. And I wonder, would you say that this continued exposure is justified? Which regional instrument perhaps would apply in this instance when you are looking at the issue of welfare and rights of children? Any instrument that comes to mind? Fauzia, would you want to try?
Yes, thank you for the question, Your Excellency. Under the African Charter on Human and People's Rights, it recognizes the right to it recognizes economic rights and environmental protections, meaning they must be interpreted as one. They must be balanced and not be interpreted in in a conflicting manner. Similarly, this was confirmed in Serak versus Nigeria, where the African Commission held that environmental protection must not violate other fundamental rights like the right to livelihood and the right to livelihood. Yes. And yeah, my co-counsel Nahum Juma can expound on the rest.
Honorable members of the court, if I am to add on what my co-counsel has just said, I'd like to point out on the Convention on the Rights of Child, the CRC, stating that at the universal level, the Convention of the Rights of the Child reinforces this approach. And this is evidenced by Article 24 of the same convention, which advocates for the right to health, including environmental hygiene, and also Article 27, which provides for the right to an adequate standard of living. As this CRC makes it legally impossible to protect the children's health by measures that undermine their subsistence, nutrition, education, or family stability. And the legal answer to the court's concern, honorable members of the court, is that the dilemma you have described is very real. But I'd like to point out that international law already provides the answer, as children must be protected from pollution, but they must not be protected into poverty. As destroying 2.5 million livelihoods, most of which sustain households with children, creates food insecurity, loss of school attendance, child labor risks, and also long-term developmental harm, apologies, and that outcome violates the same children's rights instruments invoked to justify protection. And what the ICJ requires in such situations, I would say that the International Court of Justice advisory opinion on climate change reinforces this harmonized approach, as the court held that states must address climate and environmental harm, but must do so consistently with human rights, including the right of vulnerable groups, such as these children. And they must also adopt context-sensitive, proportionate, and capacity-aware measures. If I've answered your question, presiding judge.
Thank you very much, Counsel. Yes, you have answered my question, and I want to thank both Counsel for Sika as well as Azenia for your responses to issues that the court needed clarification from. I think at this point we have exhausted what we had on our plate in terms of clarification from your submissions, and to thank you, each one of you, for your diligence in all this. I turn it back to the court assistant.
Most obliged, presiding judge. From our end, we note that the parties, the sides still have 7 minutes each. So with the indulgence of the court, I don't know if the court can allow them to make final submissions in the line of questionings that they were given, and then now the judges can retire. Kindly please guide. Thank you.
Certainly, and I think it is only proper that that happens, and we will allow Azenia to make their concluding submissions, including the prayers that are sought.
Note you have 7 minutes to do that.
Much obliged. Much obliged, Your Excellencies. I intend to take, with the court's permission, with the Honorable Court's permission, I intend to take just 2 minutes to perhaps make clarification on some of the questions that this Honorable Court has fronted to members of SECA. I will further allow my co-counsel the remainder of the 5 minutes to give the brief of our submissions and further to give the reliefs that have been sought. I hope that is sufficient, Your Excellency.
That is in order. Counsel, please proceed.
Much obliged. I'd like to begin with the question that President Emukule presented to SECA, which was in regards to the principle of common but differentiated responsibility. This principle, contrary to the determinations that have been made by the co-counsels who we do respect, were in fact addressed by the ICJ advisory opinion of last year, specifically under paragraph 148. They recognized the need to distribute equitably the burdens of climate change, taking into account historical contributions as number one, and number two as well, taking into account the different capabilities of countries, and number three, the national circumstances, which include both the social and the economic aspects of both parties. So in this regard, to clarify perhaps on that question that was fronted to SECA, that it is in fact the Global North's responsibility to contribute towards a fund for mitigation and adaptation. And that is precisely why the GCF and the GEF exist for this particular purpose. If that is sufficient, I wish now to cede the floor to my co-counsel, who will give the brief of our submissions and finally give our prayers.
Thank you, Counsel.
Much obliged.
Thank you, Your Excellency, for the opportunity. I will summarize our submissions as follows. On the issue presented whether the ICJ advisory opinion affirms a positive obligation, we submit the ICJ advisory opinion did not create a new law. However, it went ahead to clarify existing laws. We submit that indeed it affirms a positive obligation upon states, and this obligation is anchored from the decision by the ICJ advisory opinion, whereby it specifically stated that transboundary obligation is reinforced by specific principles of customary international law. These principles include common concern for humankind, common heritage for mankind, the do no harm principle, as well as the precautionary and preventive principle. Your Excellency, we submit that international obligation puts climate change as a common good for global. Then it means that it raises a common concern for mankind, which puts an obligation on erga omnes obligation. This obligation ensures that all states act concerned to matters of climate mitigation as well as protection of the climate. This principle was defined in the case of Belgium v. Spain, whereby the ICJ stated that specifically there are some obligations which require all states to act upon it. To this extent, also under paragraph 282 of the advisory opinion, the state is obligated to ensure that there is a regulatory framework for transboundary value chains, which include both public and private sector. Your Excellency, on issue 2, as to whether prior to the enactment of the Act, the state of Tanzania breached the due diligence obligation. We submit that the due diligence obligation takes different approaches. One, it requires states to work with the duty to prevent significant harm to the environment. However, state is required to take various appropriate measures, and this was actually expounded in paragraph 101 of the pulp mills case. The same was also reinforced in paragraph 182 of the ICJ advisory opinion. However, it is an obligation upon states to also act based on scientific and technological information. We submit that at the very moment the state of Tanzania received the scientific information, it acted and proceeded to enact that specific act. But also, the action was based on its capability as a state, as well as application to the relevant international rules and standards on due diligence. We therefore submit, Your Excellency, that indeed the state of Tanzania did not violate the due diligence obligation, as it had not the scientific information then to act on this obligation. Your Excellency, to summarize on the issue as to justification on the limitation of trade, we submit that the state of Tanzania acted and complemented the existing international trade laws, but also taking into consideration the lex specialis principle, but also into consideration Article 20 of GATT. We therefore submit that the actions by the state of Tanzania are justified, as it is in line with its obligation on climate change and environmental matters. That marks the end of our submission. We humbly submit to Your Excellencies. Thank you.
Thank you, Counsel. We now invite maybe before I invite the other side, my sister, Judge Ogange, from that summary, is there anything that needs clarification?
No issue, presiding judge. Thank you.
Judge Mufule?
No issue. No issue on the submissions, my lady presiding judge.
Thank you. So we now invite counsel for SICA to then make their closing remarks and also perhaps include their prayers. You will decide on how you want to approach it.
Please note you have 7 minutes for that. You have 7 minutes for that.
Much obliged. Honorable members of the court, it is an honor to present before this honorable court once again, as I would like to use the next 3 minutes to answer to what our learned friends imposed on us on the matters brought before by the first learned person. And my co-counsel will use the next 4 minutes to give a summary together with the prayers sought for relief. To begin with, I will be brief and confine this point into 3 decisive points. First, I'd like to submit that Azania conflates the existence of climate obligations with the lawfulness of their implementation. We submit that SICA does not dispute that Azania is bound by international environmental obligations, not that it must act to prevent harm. What we dispute is the assumption that the mere existence of those obligations immunizes any regulatory measure from legal scrutiny. As the International Court of Justice advisory opinion is explicit, climate obligations are obligations of conduct and not of result, and must be implemented consistently with other binding rules of international law. We humbly submit that environmental sovereignty is therefore conditioned and not absolute, as a state may regulate, but it must be able to regulate proportionately, non-discriminatorily, and with regards to social and economic realities. The treaty fails that legal test. My second point, that the no harm rule does not justify objective regulations. We humbly submit that Azania has relied heavily on the no harm principle, as SICA accepts that principles as customary international law. That the court has consistently held, pointing out the case held from the pulp mills of the 2025 advisory opinion, the no harm rule is implemented through due diligence and not through maximalist controls. Due diligence, therefore, requires risk differentiation, calibration to capacity, and also the consideration of restrictive and alternatives. Honorable members of the court, we humbly submit that here the uncontested evidence shows that the 35 to 45% of imports constitutes waste. And yet Azania regulates 100% of the sector, including legitimate circular activity that reduces demand for new and carbon-intensive textile products, and that is not harm prevention, it is regulatory overreach, honorable members of the court. On my last point is that the children's rights require harmonization and not substitution. We humbly submit that much has been said about the protection of children and coastal communities. SECA is unequivocal in that continued exposure of children to pollution is unlawful and unacceptable, honorable members of the court. But international law, particularly the African Charter on the Human and Welfare of the Child, specifically Article 14, provides that it does not permit states to protect children's health by collapsing the economic foundations of their families, honorable members of the court. We humbly submit that children's rights include health, environmental safety, and an adequate standards of living. Therefore, honorable members of the court, destroying 2.5 million livelihoods in the name of environmental protection creates new unforeseeable violations of the same children's rights Azania claims to protect. We humbly submit in my conclusions that the ICJ advisory opinion rejects false binaries. It requires integrated solutions that protect both the present and the future generations, which is shedded light in the intergenerational principles under the sustainable development. Closure to my submissions, honorable members of the court. SICA does not ask this court to restrain climate actions. We simply ask the court to affirm what international law already requires, as climate action must be lawful, equitable, and proportionate. Where regulation harms livelihoods without necessity, honorable members of the court, fails to differentiate risks and ignores available alternatives, it ceases to be due diligence and becomes a breach. Unless the court has any questions, those are my submissions. I now seek the floor to my co-counsel. May it please this court.
You have 2 minutes to go.
Thank you. May it please this honorable court. This case concerns the regulation of transboundary circular apparel value chains at the intersection of climate law, trade law, and human rights. The coalition submits that while states have sovereign regulatory space in environmental protection, that space must be exercised consistently with international legal obligations where measures affect trade and legitimate economic actors. First, climate law requires that such measures be proportionate, non-discriminatory, and carefully calibrated so as not to unduly restrict legitimate circular economy activities. Second, Azania's pre-Twitter conduct did not constitute an internationally wrongful act. Developing states are entitled under the principle of common but differentiated responsibilities to face implementations of environmental obligations based on their capacities and national circumstances. Third, under Article 20 of the GATT, General Agreements on Tariffs and Trade, environmental measures must be necessary and proportionate and must not result in arbitrary or unjustifiable discrimination, including where less trade restrictive alternatives are reasonably available. Fourth, digital traceability and extended producer responsibility systems must account for differential capacities. Uniform obligations without flexibility or support the risk crossing into unjustifiable discrimination under international trade law. Fifth, environmental protection must be balanced with human rights. The rights of the child and intergenerational equity require that climate action safeguards future generations while not disproportionately harming present livelihoods. Finally, Your Excellencies, circular economy actors engaged in reuse, repair, and resale are key partners in climate governance. States therefore have a positive obligation to recognize, support, and integrate them into regulatory frameworks. For these reasons, SICA respectfully request this honorable court to grant the declarations set in our memorials. Most obliged.
Thank you very much, Counsel. I'm sure memorials, it would mean something totally different, but thank you very much indeed. So we get back to the court assistant for further protocol.
Thank you very much, Presiding Judge, for that session. That marks the end of those submissions. Allow me to break protocol with the kind indulgence of the bench. The Presiding Judge was big on the Rio Declaration, and we have the author of implementing the Rio Principle 10 Declaration guide who wrote it on behalf of UNEP. He's on call, our advisory board member, Professor Stephen Steck. Professor, I don't know if you are on call. I can see you. I don't know if you have a second to just greet us and tell us something, tell the participants something before we, thank you, Professor.
Hello, everyone. Well, thank you for this nice introduction. And I just wanted to say I've had a chance to listen a few times. I haven't been able to catch all of the arguments so far, but I wanted to, as we're getting closer to the end, I wanted to check in and see how it's doing. I was very impressed, and I want to congratulate everybody going forward and wish you luck in the next coming rounds.
Thank you very much, Professor. We truly appreciate your support thus far. Thank you. Now the judges will retire. and go to the chambers to deliberate, and then we'll be back in 10 minutes to issue the determination. Judges can kindly leave the platform and we meet at the chambers. For the rest, remain on call. We'll be back with the determination shortly. Thank you. We are back. Rather, I'm back. I believe the judges will join shortly. They're here. So participants, kindly please switch on your cameras so that at least I see you when I'm addressing you with the power given to me by the court to give you your feedback. I'm going to start with feedback for Castro, representing Azania from JKUAT University. So for Castro UMMA, the bench notes that you are an excellent future counsel and you should keep up the good work. You're very well structured, articulate, and confident. You are impressive and passionate, the bench observes. For your counterpart, Carrera Levis, the bench observes you are clear in your issues. You have a reasonable understanding of the law. You are courteous. You have a good application of the law. This comment comes again twice. It came in the first session. It's coming again, that you seem distracted by your background. And according to my assessment, I believe you are seated in the same room with Castro, so you might be seeking clarity on something, so you look distracted. So I believe you're supposed to look on that because it has been mentioned twice. So check on that. To the second side, UMMA University. Nahum Juma. The court indicates you're an excellent student with great potential. You have a good grasp of international law. However, you appeared a bit flustered. You are not calm, which interfered with how you address the court. So try and be more calm and more confident as you submit before the Honorable Court. For your counterpart, Fozia Hassan, the bench notes that you have potential, but you need to be composed. You are also flustered. You seem distracted. However, you have a good grasp of legal instruments. And the bench observes that perhaps the interrogative approach, which the quarterfinals has taken, threw you off balance a bit. So you need to be more responsive and to be able to think on your feet. And with that is your remarks and your feedback. As usual, by tomorrow morning, you'll have this. You'll have the awards just as we did, just as I have been sharing with you the comments as well as the individual scores that you scored for the sessions. You'll have them by tomorrow morning in your emails, and then we can proceed from there. For now, let me give it back to the bench to issue their determination. Welcome, Presiding Judge.
Thank you. So, we acknowledge that we adopted an approach which perhaps both teams had not expected, because it was more interrogatory and you probably had prepared to make submissions in the usual custom. We appreciate that although initially it took you off balance, both teams were somehow able to get back on track and follow the trend of what was the court's preferred mode of operation today. So after taking into account issues regarding knowledge of the law, the application and analysis of the law, and its relation to the situation at hand, the structure and clarity with which you delivered and responded, the advocacy skills applied, and your use of authorities, and of course your responsiveness to the bench during the interrogations, we find that UMMA University has a score of 78%, whereas JKUAT University has a score of 83%. So JKUAT carries the day. Thank you, and back to you, Court Assistant.
Thank you very much, presiding judges. As you have indicated the scores, you have now seen the scores. Remember, the criteria for moving to the semifinals is still the top four, the first four. So losing, rather becoming second place in this session does not mean you're out. You just need to hope that the others perform a little bit lower than you. As I observe, you can see the marks have gone down as compared to the preliminary rounds. So it shows that the competition is becoming more and more tighter. So I'll urge you to, that is the approach which will be adopted throughout the quarterfinals. It will be interrogative and then a few minutes just to issue those submissions, and the questions will not be the same. So if there was a team which was here and is appearing tomorrow, the bench will be different tomorrow. So those questions will not be the same. So each bench will have its own questions. So I want to thank you. Tomorrow's session, quarterfinals 2, is between the Great Zimbabwe University, Herbert Chitepo Law School versus Lead City University from Nigeria. Same time, same place, same link. Thank you very much, judges. If there's nothing else from the bench, the court is functas officio and we are free to leave the platform. Thank you very much.